And we've reached one of my other favorites, and that's criminal law. Yay! So next week is criminal procedure, and that's the last lecture that we'll have. But this week, we're going to kind of dig in. If you aren't taking criminal law in the fall, you absolutely should. I can't stress that enough. And if possible, you should come do it with me in person because I'm teaching it on Thursday nights. I don't remember the time, but you can look at the schedule. So a crime is an act that's positive or negative, or an omission to act that violates the penal code of the state or federal government. The two things that you need for most crimes is going to be the mens rea, which is the guilty mind, and the actus reus, which is the guilty act. There are laws that are going to be strict liability, but those don't require a state of mind to be included. They only focus on the actual act, but the rest of them do have that state of mind requirement in order for there to be any kind of criminal liability. So they're looking for that guilty mind or having that criminal intent, okay? They're going to be looking at what was the person thinking at the time that they did this. As my professor would say when I was in law school, that it's all about the intent. It's about the objective manifestation of the subjective. What were they doing that you can show basically what they were thinking? So is mens rea motive? No, they're not the same. So let me show you why they're not the same. So mens rea is an element to a crime, whereas motive is not, okay? Now, motive still gets used, and you'll still see that it comes up in cases and stuff like that all the time. They'll talk about, oh yeah, and the motive was ... That's because prosecutors do use it to, strengthen their argument. They use it as a way to kind of show their side of things, but it's not a requirement, okay? Motive does also play a role in sentencing, and that's because, like the more intense, like the crime, then it'll come into play, particularly for that. But let's talk about what the difference actually is. So mens rea is the intent that the person acted with when committing the crime. Motive is the reason the person committed the crime. So you have A and B, and they're married. And he learned that she has been having an affair with a neighbor, and out of anger, A takes out his gun and he shoots B. She dies as a result. So, breaking it down, you have the guilty act, which is shooting B. His intent was to kill her. And the reason, or his motive, was that he was angry about the affair. So hopefully you see what I'm talking about there, and how it works. So his intent to kill because he was mad. So A and B are married, and she has a terminal illness, and she's in a lot of pain, and she begs him to help her die. And he takes out his gun and he shoots B, and she dies as a result. So let's break this down. You have the guilty act, which is, again, shooting B. You have the intent, which is to kill her. Same thing. But his reason is to help her not be in pain any longer. So it's good motive. Does it matter? No, it doesn't matter. His whole, it's about intent, because remember, the reason doesn't matter. All right, so general intent crimes are different from specific intent crimes, but we'll get to that in just a second. So they just require the intent to commit a crime. It does not matter what the outcome is, okay? Prosecution has to prove that they intended to take the act that resulted in whatever outcome happened. And they can be convicted even if they never intended to violate the law and if they didn't know that whatever it is that they were doing was criminal. Intent does not have to be specifically proven in these cases, and this is where we see a lot of circumstantial evidence that gets thrown around. Because think about it. When we're talking about having to show what the person was thinking, we don't typically have it to where they write on the wall and they say, like, I meant to kill her because I hated her, whatever. We don't have all of that typically laid out for us. We have circumstantial evidence that comes together to try to pull all that together. We cannot see the thought process. We can't see what's going through their head. We can only do it through really conjecture. So they have to show that they intended to commit this act, by just showing that the act was done voluntarily. Let me give you an example. So A gets angry with B. He picked up an open bottle of bleach and he threw the liquid in B's face. She was blinded as a result. A claimed at trial that he didn't know it would cause blindness, and he also didn't know that throwing bleach at somebody was illegal. So let's break it down. You have the guilty act, which is throwing the bleach. You have the intent, which was to throw the bleach. He didn't intend to cause blindness. He just intended to throw the bleach. And his reason was because he was angry. So this is a situation where, you have somebody who doesn't know that something's illegal, doesn't know the outcome is possible. I'm not sure how, but again, they can still be convicted. Now, specific intent crimes do require proof of general intent to commit an act, and then it has to go beyond that. So it has to be something more. And the prosecution is going to have to show that the defendant intended to commit a specific goal, okay? And the purpose is the result of the act that they're looking for. So, for example, all right, common law burglary is a good example of a specific intent crime. So the elements are breaking the threshold of a dwelling of another, entering the dwelling of another. Those are two separate things. I know you always hear breaking and entering, but they are two different things. At nighttime, with the intent to commit a felony once they're inside. So as you can see, there is the general stuff, which is just about entering someone's home at night, but it has to be done with that something more. And that something more is that intent to commit another felony once they're inside. Let me give you an example. So A broke into B's home on Friday night to steal her TV. The police arrived before he could get the device out the door. So breaking it down, the guilty act is breaking into the home. His general intent was to break into the home. His specific intent was to steal the TV. And the reason was he just wanted to. So with specific intent, it cannot be inferred from just the act. You have to have that specific proof to show that the specific intent existed. So for example, like A was caught with the TV in his hand while trying to leave. So that shows that he specifically entered to steal something, which was the TV. And think about it. Maybe he entered initially and he didn't have the intent to steal the TV. He just had the intent to go in and look around and check something out, but he walks out with that TV, and that circumstantial evidence right there is going to go against him because it's going to show, well, he was in there for some reason. He had to have been in there to get the TV. So actus reus is your criminal act, and you can be convicted for failing to act, or we call it an omission to act. And you have to show that the person made a conscious, volitional movement, and you don't have to have any evil intent or anything like that required. Just like with torts, reflexes, movements during sleep, actions under hypnosis, things like that are not product of effort made by the person. An exception would be if the person causes the unconsciousness. But I'm going to give you some examples. So A was having an Ambien-related sleepwalking type of night, and he takes a gun to shoot B, and he wakes up in jail. So this would not support a conviction because he was unconscious at the time. But let's keep going. A and B go out drinking one night. While very intoxicated, A takes B's head and slams it repeatedly on the bar, and B dies as a result. Well, while A was unconscious, he voluntarily got intoxicated. So it's kind of like exactly with the tort stuff that we discussed. Again, it's about what they caused, right? And he caused himself to be intoxicated. Now, I know that you might be thinking, well, there's a difference because that other person was also, voluntarily taking Ambien. And that's true. The difference is that one is a prescribed substance, whereas the other one is something that you can just purchase. Now, if they were abusing the Ambien, then that could be a completely different scenario. But for all intents and purposes here, we're going to assume that they were taking it as prescribed. All right, so A has been diagnosed with narcolepsy, and he decided to take his new car out for a spin. He fell asleep while he was driving and ran off the road into a parked car that had passengers inside, and they died. What do you think about this one? I know, because it seems like Well, you have a situation. He's probably under, the guidance of a doctor. Maybe not, but we'll assume that he was. But still in this case, you have A, who was unconscious at the time, but he knew about the risk of falling asleep while driving. So that right there kind of changes it. So you have the omission to act, and this is where you have a failure to act when legally required to, okay? So the prosecution is going to have to show that there was a legal duty to act, that the defendant knew that they needed to act, and that it was possible for the defendant to act. But what does it mean that they had a legal duty to act? That is where you have a duty by statute, and that is where there's liability to assist those in danger. So, for example, a fire person, they are sent to a home to battle a fire, and they have to, go in, and they have a duty to assist by law. You have duty by a relationship, and that is going to be like the parent, child, spouse. Again, you have to help. A duty by contract, a doctor-patient, bodyguard-client. Doctor-patient is not necessarily a specific contract, but like a bodyguard-client is. But the implication is still there between the doctor and the patient. You have the assumption of duty, and that is expressed verbally or it's in writing. And then you have the creation of danger. So if you create a dangerous situation, then you have to help. So if you're driving down the road and somebody's riding their bike and you hit them on their bike, and let's just say that you come too close to them and they end up falling and they fall into the road. Well, you've created that dangerous situation. So you got to go help them get out of the road. So you have two categories of crimes. You have the misdemeanor and you have the felony. Now, the difference is the misdemeanor is any punishable offense by fine or confinement for less than 1 year in jail. The felony is any offense that is punishable by death or confinement for more than a year in prison. That's the difference between prison and jail. It's about the duration of time. It's governed by common law and the model penal code. Now let's talk about inchoate crimes. These are honestly probably some of my favorites, and they are just simply incomplete crimes. And you have three types. You have the attempt, the conspiracy, and the solicitation. There is something called the merger rule, which means that if you have a completion that happens, then it will merge in with the actual crime. And that would be an exception there would be conspiracy. So, for example, if you have somebody who attempts murder and then the murder is completed, well, you don't want to charge them with attempt and then murder because that doesn't make any sense. It's going to merge just into the murder charge. Now let's talk about them in a little more detail. So, attempt is the act of making an effort to accomplish something, and this is a specific intent crime. So you have two basic elements. You have the specific intent to commit the crime, and then you have that overt act towards the completion of the crime. So the specific intent, you have to have the intent to commit whatever is necessary that you're going for in regard to the commission of the crime, okay? So you have to have the intent for the result of the crime. So, I do want to point out that this is missing from all crimes except the specific intent crimes. This is how else you know. So you have to have that intended result, right? So like murder, take murder, for example. It is a specific intent. You have the specific intent to kill somebody. So you have, it might not be that you have the intent necessarily to shoot someone because maybe that's not really what you want to do, but you just really want them to die. Right? And you want that end result. That's what you're really going for. And so it can be any method. It's the end result right there. So when you're talking about an attempt, it doesn't have to be attempted murder, and it can be a general crime that they're attempting. But the attempt itself is a specific intent because you're looking for the intent to have that result. That crime now is basically the result. And I hope I didn't confuse you too much. Again, shameless plug, criminal law in the fall. We'll talk about it in way more detail. So the overt act has to be something that is beyond simple preparation, okay? This is a model penal code, and it requires that the act be a substantial step that's in furtherance of the crime, and it has to be strong evidence of their criminal purpose. Let's talk about what that means, though. So a substantial step would be something like lying in wait, luring a victim, staking out a place where the crime will be committed, unlawfully entering a place where the crime will be committed, gathering of material necessary to commit the crime at or near the place intended to commit it, and soliciting another person to assist in criminal activity. Solicitation. This is where the defendant advises, encourages, induces, or requests another person to commit a crime or to join the defendant in committing a crime. Under the common law, it is a misdemeanor, even if they're soliciting somebody for a felony crime. And with the mens rea, you just have to show that they acted voluntarily with that intent to cause the other person to commit the crime. The actus reus part is the advising, encouraging, inducing, or requesting another person to commit the crime. And it is complete upon asking, okay? It does not require that they go out and commit the crime. It does not require anything else. It simply requires, for example, me saying, hey, you want to go rob that bank? And that's what I'm intending to do. Like, I'm wanting somebody to come join me in this crime that I'm about to commit, right? So if I say, hey, do you want to go hey, come commit this crime with me. Let's go do this. We'll split it 50-50, whatever. It can look like a multitude of things, but again, it's complete upon me asking you basically to join me in committing this crime that I have planned. They can be convicted even if they ignore it completely. I cannot stress enough that I can't think of an area of law where silence is not an affirmative, okay? Always speak up. Conspiracy is simply an agreement between two or more people to commit a criminal act. If you say yes back to me to go rob the bank, well, now we're in a conspiracy too. So elements required is the mens rea has a 2-prong test, and then you have the actus reus. So you have to actually intend to agree to commit the crime. So you can't just be playing with me. You have to actually agree. And you must have intended to accomplish the objective of the conspiracy when entering into the agreement. And that's where you're going to show that they have that stake in that venture. And that's going to be us, the whole like, hey, we'll split it 50-50. The actus reus is completed upon you saying, yeah, let's do that. You have to have 2 or more people because obviously you can't enter into a conspiracy with yourself. And it doesn't actually have to be expressed. And in the fall, whenever I do criminal law, or if you take it with the other professor, we'll talk about that a little more in detail about how your action can end up getting you into conspiracy as well. So many jurisdictions do require there to be an overt act, and they can use actions of a third party to prove involvement if they're able to prove that a conspiracy exists between the first 2 people. And I have a really, really good story about this one that I will share in the fall as well. So where you have multiple people with multiple transactions, with conspiracy, of course, you have 2 different kinds. You have the chain and link, and then you have the wheel and spoke. And the chain and link is basically a series of overlapping transactions that involve only one agreement. For example, and think about it as a chain with links. You have a segment of chain that has, say 5 links, and you're purchasing drugs from, the person that you buy it from. Unless they are, have a farm of marijuana out in the backyard or something like that you physically see, then you know that they have to be getting it from somewhere else. So again, you know that there are more people involved in this, and that's what makes it a chain and link. It's still just one agreement. It is the agreement between you and your supplier, but your supplier has a supplier who may have a supplier who may have a supplier, and it kind of goes up the chain to get down all the way to you getting the product. Hopefully that makes sense. I actually have some drawings that I use for it in the fall. The wheel and spoke is one person. So you've got the wheel, and they have different agreements with different people who are independent of each other. And the person essentially is the hub of the activity. And RICO cases are usually like this. For example, Think about it as the center of the wheel, right? You have that person who is making agreements, going down. Just think about like the rims on a tire. They're going down all the different, like branches of the rim. I don't know what you'd even call them, but it's going out to the wheel itself, but it doesn't mean that they're getting there together because they're all independent spokes, right? That's what they're called. Anyhow, so my point is that in these particular cases, you have that one person who's making it with a whole bunch of people. There was actually a case, and I can't remember which movie theater it was that was involved in this, but there was a RICO case where there was a movie studio who was doing they had a conspiracy with a movie theater chain. And anyhow, it ended up being an issue because not all of the theaters got in on it. And so, but you had some of them that did, but there was this, but the hub of it was the movie company, was the production company. And then the rest of it, they were all independent agreements from there. Like you literally had to contact each individual person to make the agreement with them. So hopefully that makes more sense. I know, again, I do better when I have my drawings. So let's talk about parties to a felony. You have the principal in the first degree, principal in the second degree. You have the accessory before the fact and the accessory after the fact. The principal is the one who actually commits the crime themselves, or they cause an innocent person to commit it. Did you guys see? This is one of the reasons why I hate the summer semester, by the way, because this is one of those situations where I like to say, have you seen, and like actually get the answer back from you. So there was a thing that was on, I think it was on Netflix or something, but I can't remember what it's called. I think it was like The Heist or something, but it was a piece that was done on this bank robbery job where they had, there was these people who had called for pizza to be delivered, and then they put this bomb collar on the pizza delivery person and made them go and, rob the bank. So they gave him the note and everything for them to go in that said, if you don't give it to me, then this is going to be detonated. And anyhow, so that person is innocent, but the people who made him do it, they would be considered principals in the first degree. If you haven't seen it, go check it out too, by the way. It's weird. So principal in the second degree is somebody who encourages the commission of or assists in the commission of, and who is at the scene of the crime, and they can be constructively present. And I'll give you an example of what that means. So let's say that you have somebody, we'll take the bank robbery, for example. So you might have people who are not the bank heist, by the way. We're going to switch to a separate bank robbery. But let's say that you have somebody who's going to physically go into the bank, but you have somebody who worked in the bank who drew out the plans for you to tell you like where to go and, make sure you stand here and so that the camera doesn't get you or whatever. That's going to be somebody who is a principal in the second degree because they are assisting in the commission of that crime. Now, when it says that they can be constructively present, let's say that you have somebody who agrees to be your lookout. That person can be right outside and they can be your lookout while they're maybe sitting in the car. Maybe they're going to be the getaway driver. And, they can walkie-talkie you and say, hey, the cops are here, something along those lines. But you could also have it to where they're like across the street hiding in a bush with binoculars and a radio. And in that case, they are still constructively present because they're still participating in the crime that's being committed, essentially. So an accessory before the fact is someone who encourages or aids in the commission of felony, but they are not actually or constructively present at the time of the commission. So let's say that you have the person who's in the bank, but they decide they're going to call out that day, then they could be considered an accessory before the fact rather than a principal in the second degree. And an accessory after the fact is going to be a person who gives post-crime assistance, and they must have known that the person that they're helping did commit this felony. So the intent that they're going to be looking for is somebody who intends to interfere with the capture, prosecution, and or conviction of the person. So if you have somebody who comes and wants to hide a stolen car at your house, and you know this person does not own that car, you know there's something up. So you might not have, actual knowledge, but you know this person well enough to know that if they're saying, hey, can this hide here for a minute? There's something wrong, and you agree to it. Or for example, let's say that you know that your kid did something wrong and the cops come to your house and they're like, hey, we're looking for so-and-so. And, we've got a warrant for them, and you're not, giving them up because maybe your kid is in hiding in Mexico or something. Again, if you're interfering in any way, shape, or form, then that means that you're going to be considered an accessory after the fact. All right, when it comes to serious felonies, your book lists assault, battery, theft. That is usually the same as larceny, but it could be theft by taking, theft by receiving, robbery, larceny, and homicide. Now, I will say that the best way that I think you can kind of remember the bulk of this is by using bark or breaks plus homicide. So burglary, arson, rape, robbery, kidnapping. And then you have burglary, robbery, arson, kidnapping, escape, and then sex crimes. Again, just an easy way for you to kind of remember like the bulk of it. I know it doesn't have like the theft part in there or the larceny, but that's because, in all honesty, in law school, we learn that these are more of the serious felonies. Of course, it's a serious felony when you're talking about, taking like somebody's car or something like that. But the rest of these all involve basically something with the actual person themselves. And of course, we'll get more in detail with that when we do criminal law. But I'm still break it down for you just a little bit. So larceny. This is the taking and carrying away of personal property of another person with the intent to permanently deprive the owner. So we're looking for any tangible property that is going to be subject to this. And that does include livestock, but it does not include house pets. That falls under something else. But anything physically attached to the ground cannot be considered larceny. And that's because it's attached to the ground. You're not taking and carrying away anything. It has to become severed. Okay. If it becomes severed, there's still a distinction on what happens to it after it's been severed, on whether or not it becomes larceny or not. So if it becomes severed, then it can be larceny unless the defendant severed it specifically to take it down. Okay. We're looking for whether or not the owner came back into possession of it before the theft took place. So for example, let's say that there is a tree that, they're wanting to chop down to make some firewood with, right? If they go and chop down that tree and then take it, that's different. That's not going to be larceny. But if that tree came down and it, fell to the ground and it was there, and then they go over and they start hacking it up into little pieces and then taking that off, then that is considered larceny because it became the property of the owners the minute it touched that ground that it came from. Modern statutes do allow for intangible property, and intangible property would be things like, the stocks and bonds and stuff like that. To be convicted, the mens rea is that you have to have that actual intent to deprive somebody permanently, and it has to have been carried away. The taking has to have been wrongful, and the property must belong to another person, okay? When it comes to carrying it away, the slightest movement is enough, okay? When it comes to the taking, there is no consent. If there is consent, it's going to be considered larceny by trick. And then the property must belong to another. It could be your own property, but the possessory rights are greater than somebody's ownership rights. So that would be along the lines of if you rent your car to somebody and then they have the car and you decide, you know what, I'm going to go take my car back. And it's during their time that they've paid for, that's going to be a problem because their possessory rights are now greater than your ownership rights. Robbery is the forcible stealing of property from the person in the presence of the victim, and it's accomplished by force, violence, or threat of force or violence. It is literally larceny plus force, okay? So they're going to have to prove all the elements of the larceny plus 2 additional things. They're going to have to show that it was taken in the person's presence or from them specifically, and that it had the violent aspect of it or the threat of it. Now, presence is defined as being close enough so that it's within their control to the extent that it could have been prevented from being taken had it not been for the violence. And the violence part does not mean that there has to be an injury or even any kind of physical contact. Again, we can have just the mere threat of it. And pickpockets, whenever they do their thing, that is not typically robbery. It is larceny. And that's because you don't have that awareness aspect of it when it comes to meeting the larceny plus the force. And there's usually not force either. It's usually like slipping in and taking it. Battery is a harmful or offensive contact that is unlawful and not consented to by the victim. So you have the actus reus part, and there is a use of force. But again, it's just like with torts. You don't have to actually injure the person, and you don't actually have to touch the person directly, okay? Mens rea, negligence, is sufficient enough to prove that the guilty mind part exists, although intentional does have its perks when it comes to being easier to prove. And it can be aggravated, and aggravated is usually where you have an intent to kill or to cause serious harm, or they have a weapon. Assault is the reasonable apprehension of an immediate battery, or it's an attempt to commit a battery. So it's a little bit different than the tort. And there are 2 categories here. Again, you have the attempted battery, and then you have the intentional placing the victim in fear of the battery. When it comes to the attempted battery, they have to have that intent to use the force against the victim, and there has to be that overt act. When it comes to placing them in fear, though, this is going to be the same as the tort itself. And this one can be simple or aggravated. Simple is going to be a misdemeanor, whereas aggravated is going to be a felony. And the felony is going to, again, be your intent to kill, or you're going to have the use of a weapon. Homicide is the killing of another that lacks sufficient justification to relieve defendant of criminal liability. All right, under the common law, there are 3 classifications when it comes to liability. You have the justifiable, the excusable, and then you have the criminal. The justifiable is authorized by law, and it is not punishable at all. With the excusable, the person is at fault to an extent, but because of some other circumstances, pursuing it as a criminal homicide is not appropriate. And then criminal is going to be anything that is not justifiable or excusable. Under modern law, there is no difference between the justifiable and excusable. Categories of criminal homicide are going to be murder, murder in the first degree, murder in the second degree. You have some states that go further than that. You have capital murder, felony murder, voluntary manslaughter, involuntary manslaughter. Murder is the unlawful killing of another with malice aforethought, and this is under the common law. Malice aforethought is not the same as premeditation, but it does contain premeditation as an element of it, okay? This is the mens rea for the common law murder, and it includes the intent to kill, the intent to commit a serious bodily injury, intent to commit a felony, or some sort of display of depraved indifference to human life, and they will call this implied malice. First-degree murder is simply the statutory version of murder. So remember, the other one is common law. This is the statutory. And there are 4 categories that are under this. You have the premeditated. You have the intentional homicide during the commission of certain felonies. You have poison, explosives, or lying in wait. And then you have torture. Now, under premeditated, you have to look at the consideration and or planning that goes into this that precedes the actual act itself. The intentional homicide that is during the commission of certain felonies, that's going to be your breaks, your burglary, your robbery, your arson, kidnapping, escape, and sex crimes. Second degree murder is essentially a catch-all category. It is for everything that doesn't fall into first degree, okay? And they typically use this as a plea bargaining tool. Capital murder is first degree murder plus an aggravating factor, and it does vary by jurisdictions. So it would be like the killing of a judge or witness, and that's because they're looking to influence the outcome of their proceedings. Killing of a cop during the course of their duties, multiple killings, so serial killers, and murders for hire. So felony murder, this is a rule that states that a death resulting from the commission or escape from certain types of felonies will subject the felon to liability for that particular murder. So it's committed during the commission of a crime. The intent to kill, they don't care. They only look to whether or not they intended to commit that felony. It can be accidental. It can be intentional. Again, they don't care. And it can even be the death of one of the felons as well. Where there are multiple parties, though, if one is guilty, they're all guilty. Okay, that's just the way that one typically goes. But this would be like if you have a situation to where you are part of a group who's going in to rob, say, a convenience store, and the clerk gets shot and they die. It doesn't matter. I mean, you'll end up, the felony murder rule is going to get attached because it was committed during the commission of a crime. Voluntary manslaughter is the intentional killing that gets reduced from murder due to adequate provocation of the defendant. The provocation that we're looking for here must have caused a reasonable person to lose control and act spontaneously, okay? And they have to actually have been provoked. They can't just say that they were. The period of time that is between the provocation and the killing cannot be a cooling off period. So it cannot be enough time for this reasonable person to have calmed down in any way, shape, or form. And they must not have actually calmed down. Involuntary manslaughter is committed without the intent to kill, but with recklessness or negligence, or a death that results during the commission of or flight from a misdemeanor or a felony that is not encompassed in the felony murder rule. White-collar crime is simply crime in the workplace. It's going to be your tax law violations, burglary, theft of trade secrets, damage of competitor property, and embezzlement. Persons representing corporations are going to be considered the mind of the corporation. And this is where you have a term called respondeat superior. You also have that in torts. And this is where the corporation gets held accountable for the actions of their employees. So they can't be, I mean, of course, you can't put a company in jail or anything like that, but you can at least fine them and do those types of things. Then we have some common defenses, which are going to be justifiable or excusable conduct, involuntary conduct, duress, mistake. This is going to be a mistake of law or mistake of fact, entrapment, and a whole bunch of them more. You have self-defense, self-defense of others, things like that, self-defense of property. The list goes on. So the M'Naughton rule, when you have the insanity defense, this is where they're looking for this mental impairment. And this prevents the defendant from understanding the criminal nature of the act itself, right? So this is what the test that they will use typically when they're looking to determine whether or not somebody was actually sane or not at the time. It has to have prevented the defendant from determining the legality of the act when it was at the commission point, right? You also have the irresistible impulse theory, and due to the impairment, they were just so unable to control themselves when committing the crime. And when it comes to insanity statutes, this is an affirmative defense, and the burden of proof does shift. So whereas when the case starts, the prosecution has to prove their case beyond a reasonable doubt that the defendant committed the crime. When you invoke the insanity rule, or the insanity part, defense rather, the burden of proof shifts to the defendant because now they have to prove that they were actually insane at the time. So that's it for criminal law. If you have any questions or comments, please reach out or call me or email me. And that's it. Bye.